Hello everyone, my name is Mark Veloso, a contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we will highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on LeVan v. LeVan, decided in 2008 by the Ontario Court of Appeal. This is a family law case that concerns the issue of marriage contracts, specifically whether a marriage contract can be set aside due to a lack of full disclosure. Please remember that this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. In LeVan v. LeVan, the parties were married for 7 years and had 2 young children. At the time of the marriage, the husband was very wealthy and owned shares in a family-owned manufacturing business, as well as other high-value assets. Prior to the couple's wedding, the husband made the wife sign a marriage contract, also known as a prenuptial agreement. A marriage contract is a device by which parties can opt out of most or part of the Family Law Act, its property provisions, its support provisions, or both. Marriage contracts are covered under Section 52(1) of the Family Law Act. While the Family Law Act typically calls for equalization of net family property and support, marriage contracts allow people who are married to each other or who intend to marry to enter into an agreement in which they agree on their respective rights and obligations in the marriage or on separation. In the case at hand, the marriage contract for the parties was prepared by the husband's lawyer. The wife did not receive effective independent legal advice before signing, and the husband deliberately failed to disclose the existence of certain assets prior to entering into the contract. The husband misled the wife about the true purpose of the contract, telling her that it was to keep the shares of the business in the family. However, the contract also excluded all of the husband's business interests for the net family property and severely restricted the wife's right to support. When the parties separated in 2003, the wife claimed that the marriage contract should be set aside using Section 56(4) of the Family Law Act, on the grounds that the husband had failed to disclose significant assets and had made misrepresentations as to his worth at the time of marriage. Section 56(4) of the Family Law Act allows a court, on application, to set aside a domestic contract or a provision within it in certain circumstances. The wife sought to set aside the marriage contract under 56(4) subsections A and B, arguing that while her husband provided some information, he failed to disclose the extent and value of his assets prior to her signing the contract. The husband argued, in contrast, that Section 56(4) did not apply to their marriage contract because the failure to disclose provision does not mention failure to disclose the value and extent of such assets. Set aside a contract under Section 56(4), the court had to determine whether the husband's conduct had engaged any of the provisions in Section 56. The issues of focus at trial were: first, whether the husband failed to comply with disclosure requirements under Section 56(4)(a) of the Act. Second, whether in the circumstances it was appropriate for the court to exercise its discretion in favor of setting aside the agreement. The husband argued that he had not failed to comply with his disclosure obligations pursuant to Section 56(4) of the Act, because the trial judge had erred in importing the word value into its provisions, contrary to the plain wording of the section. Those words are, if a party failed to disclose to the other party significant assets, or significant debts or other liabilities existing when the domestic contract was made. In rejecting the husband's argument, the court, in paragraph 58 of their decision, states, "There was an abundance of evidence indicating that the husband had failed to comply with his disclosure obligations, apart from his failure to disclose value for those assets. This failure was compounded by the serious misrepresentations respecting the extent and value of certain of the assets disclosed. The marriage contract itself was misleading, and the wife had no chance of understanding what she was giving up when she signed the contract." The court's principal finding of fact was that the husband had breached his statutory obligation to provide financial disclosure to the wife. However, a finding that a party has violated a provision of Section 56(4) of the Act in itself does not automatically render the contract a nullity. The next step required the court to determine whether it was appropriate in the circumstances to order that the contract be set aside. This was a discretionary exercise on the part of the judge. The quote I've chosen to highlight comes from paragraph 60 of the decision in this case. The court says, "Here the trial judge determined that it was appropriate to set aside the marriage contract. She recognized that it was appropriate to exercise that discretion, not simply because of the failure to disclose, but also because of other factors relevant to Section 56(4), such as the wife's failure to understand the nature and consequences of the contract in accordance with Section 56(4)(b). The appeal judge also noted that the trial judge had considered the fairness of the contract in deciding how to exercise her discretion. The Court of Appeal stated that fairness is an appropriate consideration in deciding whether or not to set aside a contract in the second stage of Section 56(4)(a) of the analysis. Therefore, once a judge has found one of the statutory preconditions to exist, for example, that a party had failed to disclose significant assets, then the judge is entitled to consider fairness of the contract in order to inform their discretion. The legal rules, or ratio decidendi, derived from the court's decision in this case are that a failure to make full and frank disclosure of all relevant financial information may be grounds for an agreement to be set aside. It is important to note that despite the decision in this case, it is very difficult to succeed in having a domestic contract set aside, as the courts will usually aim to respect the decision made by parties to engage in binding settlements reached by negotiation. To learn more about the court's reasoning in this decision, you may access the full case on the CanLII website link provided above. Thank you for watching, and I hope you enjoyed this installment in our series Case Law Minutes.